Section 102 tells us that this right commences as soon as reasonable apprehension of danger to the body arises. What is required is not the act itself. What is required is the reasonable apprehension of danger, reasonable fear of the danger. And this may arise not from the actual offense, but from an attempt to commit that offense, or even from a threat to commit the offense. So under the right of private defense, every attempt and every threat to commit the offense is also included. The prime requirement is reasonable apprehension of danger to the body. And this right continues as long as apprehension of danger to the body continues. Once that apprehension is over, then the right is also over. Now, the threat must reasonably give rise to present and imminent danger and not merely remote or distant danger. We saw earlier that the right commences even when a threat is there, a threat to commit the offense. But what kind of threat? The threat must be present and imminent. Imminent means about to happen. The threat should not be merely remote or distant. If the threat is present and imminent, then even though the offense has not been committed, the right of private defense of body commences and that right can be exercised straight away. Having learnt the bare provisions of Section 100 and Section 102, we will now see how these provisions have been interpreted and applied by the Supreme Court in real life, in real cases. We shall do this through the case of Devanarayan versus State of UP, decided by the Supreme Court in 1973. First, the facts of the case. There was a dispute with respect to possession of certain plots of land. This dispute led to a clash between the party of the accused Devanarayan and the party of Chandrama. During this clash, Devanarayan was first hit on his head by a lathi from Chandrama, and in retaliation or in defense, Devanarayan thrust his spear in the chest of Chandrama, which resulted in death of Chandrama. Henceforth, in this judgment, the party of Devanarayan shall be called as the party of the accused, and the party of Chandrama, the deceased, shall be called as the party of complainant. We will now see how the Court of Session, the High Court, and the Supreme Court dealt with this case. The Sessions Judge came to the conclusion that possession of the disputed plot of land was undoubtedly with the accused persons. This is a factual observation by the Court of Session. Possession of the disputed plots was with Devanarayan and party. The questions for determination before the court were whether complainant's party, Chandrama's party, had gone to the plot with an aggressive design to disturb possession of accused persons by unlawful use of force. Secondly, whether Devanarayan had exceeded the right of private defense in beating and killing Chandrama of the complainant's party. According to the trial court, complainant's party had actually gone to the plots for preventing the accused persons from cultivating and plowing the said land. The party of Chandrama had gone to the plots for preventing the party of Devanarayan from cultivating and plowing the land. Devnarayan and Chandradev received injuries on their heads before they inflicted injuries on the complainant's party. This is the conclusion of the Sessions Court. Devnarayan and Chandradev received injuries on their heads before they inflicted injuries on Chandrama and party. The Sessions Court held Devnarayan and his party entitled to exercise the right of private defense and to inflict the injuries in question in exercise of that right. And accordingly, the accused were acquitted. The matter then went to the High Court. The High Court agreed with the Court of Session that Devnarayan and party had the right of private defense and that they were justified in exercising that right. However, the High Court differed from the Court of Session as regards the extent of the use of that right or exercise of that right. The High Court came to the conclusion that the right of private defense had been exceeded by appellant Devnarayan in inflicting spear injuries on the chest of Chandrama, the deceased. The court said that yes, there was a right of private defense, but that right was exceeded by appellant Devnarayan in inflicting spear injuries on the chest of Chandrama, the deceased. So the right of private defense was exercised in contravention of the restrictions imposed on it under Section 99. And what is the reasoning? For this conclusion, the High Court reasoned that it was only if the complainant's party had actually inflicted a serious injury on the accused that the right of private defense could arise justifying the causing of death. In this case, exercising the right of private defense, death of a person was caused. The High Court is saying that this right of causing death of the assailant could arise only if the complainant's party, that is Devnarayan's party, had actually received serious injuries. In the present case, as only two members of the party of the accused persons, Chandradev and Devnarayan, had received injuries which, though on the head, were not serious, and therefore they were not justified in using their spears. Devnarayan had received injuries only through lathis, and the injuries were not serious even though they were on the head. Since the injuries were not serious, Devnarayan was not justified in using his spear against Chandradev. That's what the High Court says.